acceptances at both the houses. Conforming with the Cape Town Convention is crucial for enhancing the aviation sector's efficiency and global competitiveness, if we can say. The convention, as we are all aware, actually provides a strong legal framework for aircraft financing and leasing, which reduces the risks and costs associated with the aircraft transactions. The industry actually stands to benefit from streamlined aircraft financing processes and improved regulatory environments. This would support India's aim to become a global aviation hub, provided policy positive uh, reforms, we can say, that align with international standards are also met. The other aspect of the discussion today is on MRO policy reforms that are also very crucial as they can attract more foreign investment by reducing regulatory barriers and also will enhance operational efficiency and innovation. To shed more light on these pertinent issues and perhaps correct me if I was wrong somewhere, let me introduce to you all the speaker for today, Neha Singh, who is a counsel at Trilegal. Neha is a seasoned aviation lawyer with over 13 years of experience advising clients on leasing, financing, regulatory compliance, repossession, and enforcement matters. Her expertise spans both commercial and business aviation with a proven track record of representing international lessors, operators, banks, and financial institutions. Neha has played a key role in aircraft repossessions. Uh, Also, those are the ones triggered by the insolvency of major Indian carriers in recent past, as we have heard. She has also worked closely with the Government of India on policy and regulatory reforms to align India's aviation laws with international standards under the Cape Town Convention. So it's no doubt that she is best positioned to steer the discussions today. Her career includes significant roles at RNC Legal, Denton's Link Legal, and Flynas, where she advised on PDP financing, slot swaps, aircraft buybacks, MRO contracts, and commercial negotiations. I'm very bad at reading this uh, from a long, diverse, very impressive bio that she shared with me. So I'm just trying to capture the important ones that I can see here. This positions her actually as a very trusted legal advisor in the aviation sector. Currently, she's working with Trilegal, a major Indian law firm. Before I turn it to Neha, I just wanted to share a few housekeeping rules with all of you. Use of AI note taking or other transcription tools or chatbots are not permitted and should be please avoided. We will request you all to use the raise hand button or chat window during the open conversation session towards the end of the session today to ask your questions or share your thoughts with us. I think with that, Neha, the floor is yours and welcome once again. Over to you, please.
Thank you ever so much, Udaya, for this very kind and sweet introduction. And I think we are all, playing our role in this very, very large sector. Aviation is a big field, and because of its very cross-jurisdictional scope, you have people from multiple jurisdictions working together to ensure that we all move forward as a community, as an industry, and so that the rule making, the policy making, everything is aligned to benefit all. Because it's not possible for one to progress and the other to be left behind. One thing has a domino effect on the other, and everything gets affected together. Aviation law has been, a field which has fascinated me for a long time, and therefore I find myself contributing to this for a very long time now. It has seen immense evolution over the past 3 decades, and having been personally involved in its journey, I can honestly say that there has been a lot of hard work and sweat equity that has gone into making it a success in India. To today, when we are talking about the 2025 legislation of the Cape Town Convention's implementation in India and adoption into the legal framework, I think we have come a long way. If I remember correctly, it was Kingfisher's insolvency that triggered the entire process in action, given it was the first airline insolvency that happened after India's accession to the Convention on Aircraft Protocol, and India had acceded to the protocol in 2008. The Cape Town Convention is certainly one of the most successful commercial law treaties that we might be seeing in our times, and the kind of collaboration that it has seen across jurisdiction, the accession and adherence across jurisdiction has made business very, very predictable. More than 88 countries have ratified the convention. More than 84 countries have ratified both the convention and the protocol. Needless to add that predictability is a key component for reliance on any legal framework, which also reduces a lot of cost and expenditure that goes into the evaluation of risk and assessment of gray areas that happens from time to time, depending on which is the jurisdiction where you are going to be working on when it comes to aircraft or related transactions, particularly when it comes to rolling stocks and asset finance. In this context, it's important to assess the Indian aviation sector, which is growing at an unprecedented speed. It is the third largest domestic aviation market and is positioned to add about 2,800 aircraft into our fleet in the next 2 decades. The government and the industry are together working on building capacity and bolstering the regulatory framework to support it simultaneously. A major step in the direction was enactment was the Protection of Aircraft Objects Act 2025, which you just mentioned there, which finally makes CTC a part of our legal framework. Was it needed? Did we need it? Was it not already in force in India? Well, India works on both dualist and monist features, where we have always maintained that the moment CTC was assessed to by India, it became a part of our legal frame. It is precisely for this reason that it has taken us a very long time to bring it and make it a part of our legal framework, because for us it was already a part of it, unless it conflicted with the domestic legislation, in which case the domestic legislation would always prevail, which led to multiple conflicts, multiple situations, which we will assess in this webinar, which happened over the period over the past decade and a half, which has led us here where we felt that there is no other option but to adopt this as a part of our legal framework in order to avoid ambiguity and conflict. We will also be discussing in this webinar the reforms that have come about in the MRO sector. It's the entire building the technology, the progress around the technology, making services available from India at a very competitive cost. Internationally, we have seen that Indian MRO sector had been stuck at a certain point because they were not able to provide this service at a competitive rate uh, to the airlines or the operators across globally, because the taxes imposed on the sector was too high, because of which it has resulted in no technological progress. It resulted in very limited scope of operational capacity. It also resulted in loss of business, which has been rectified by the government. They are continually working on it. From 2021 onwards, we have seen multiple changes come about in the MRO sector, which in my limited opinion is extremely important in putting the industry forward. And we will also be touching upon this aspect during the course of our webinar. The slide that is now put displayed here only probably reflects a part of what has gone into this entire process. Certainly, the legislation was promulgated, presented into the parliament, the upper house, the lower house, president's assent. It all happened very, very quickly. And it shows the intent of the government to make it happen very quickly. And it was important because there was a lot of backlash from the community because of the Go Air insolvency that just happened. It brought to light multiple deficiencies in our system, which we had assumed have been resolved by the multiple changes that we have been making to multiple regulations under the Indian legal framework over the past decade. So, in order to understand the Cape Town legislation, the 2025 Act, it's important that we delve into what led to this. What are the changes that we did bring about to multiple legislative aspects of the Indian law over the past 10 years? What is it that we secured during that time? And then see as to what is it that this legislation brings to the table. It's a short form legislation, it's a very crisp legislation which only talks about some larger rights, implementing the Cape Town Convention in its completion, the convention and the protocol. It goes back to the definitions of the protocol and the convention. It ensures that there is no ambiguity in interpretation when it comes to understanding and assessing the convention vis-a-vis the 2025 Act when being interpreted in the Indian context. So just to take you a little, back into the entire process. Well, the need, let's start with the need for the Cape Town Convention itself. The need for CTC came into picture when the sector was being deregulated. I think it was around in the 90s, in the mid 90s, when it was starting to get deregulated globally, from being controlled by the government across the globe to being handed over for private participation. Whilst indeed it was a crucial emergence in success of the sector, it also led to failure and defaults. These were the challenges that came with privatization. And given the nature of the object itself and its cross jurisdictional utilization, recognition of rights and enforcement thereof became a very complex issue to address, particularly in view of the conflict of law principles that would come into play. Well, you see, a lessor is in a different jurisdiction, the operator is in an absolutely different jurisdiction. At that point in time, it was also important to assess as to where is it that the aircraft would be touching down, which would be multiple jurisdictions again. And it was very difficult in a default scenario to understand and to identify which is the law that would then govern the creditor's right, the lessor's right, the interest in the aircraft object, and therefore it became very prolonged. The cost of getting legal opinions and understanding of the entire framework was also extremely, extremely high, which added to the complexity quite a bit. To give you a little background, the Indian industry acceded to the convention in 2008. And whilst international convention and treaties, like I just mentioned, have a force of law in India, in the absence of a legislative enactment, what happens is, in case of conflict, the domestic law always prevails. It has therefore been a collaborative effort across the industry that is being concerned, connected, and working alongside India, is to ensure that the provisions of the convention are given the right effect, are given the right kind of recognition in the Indian context. The primary objective of Cape Town has always been to provide creditors with viable default remedies, ensuring that the concept of international interest is recognized by the contracting states and recognition of the international registry itself. So it works in dual manner. One, it creates an interest and works like a public registry for everyone to know that there is an interest that lies in favor of a certain party. And it also creates a mechanism which is across jurisdictions, recognized by multiple states. And therefore, it's very important to have the predictability and understanding that it's a uniform mechanism across all jurisdictions, no matter where your aircraft is. That in case there's a breach of your interest, in case there is a default, then you have a mechanism to go into, which provides for deregistration, which provides for repossession, which provides for getting control of your aircraft in a very time-bound manner. So Cape Town Convention came with its insane benefits at a time when, repossession, understanding of jurisdiction was extremely, extremely challenging, and the industry was facing not many challenges at the time on this point alone. What captured this entire thing in India and what catapulted the entire process at the time was certainly Kingfisher. Kingfisher aircraft were, most of them were not covered by the Cape Town Convention. We did have, if I'm right, we did have multiple leasing arrangements which would talk about the trigger of Cape Town Convention into the leasing arrangements the moment India ceded to the transaction. And most of their leases were from before 2008. And therefore, they were not covered by the convention. Despite the leasing arrangements having the trigger clause, it never really happened. It never really did hold any value when we went to deregister the aircraft to the DGCA, because the DGCA couldn't just take the leasing arrangement as something on which they could completely rely in the absence of a legal framework. So this deregistration, absence of a legal provision to support deregistration at the DGCA, brought about a very important aspect for the industry to analyze and assess as to whether or not India is a dualist or a monist nation, whether the convention is fully in vogue in India or not. But in the absence of a legislation, DGCA did not take any action. It led to cannibalization of the aircraft. It led to mounting losses. It led to a lot of money going into maintenance of these aircraft after when they were flown out of the country. And ultimately, it was the Ministry of Civil Aviation which came to the rescue of the lessors, where after multiple legal battles have been fought, even against the ministry, by the way, by the regulators, the GST department, the tax departments as to what are the losses that they incurred in this interim when these aircraft were let go. But that was one of the biggest things that happened in 2011, 2012, which initiated the entire process of rulemaking and legislative action that initiated. Whereafter, it was soon after this that we made a major change into the Indian legislation. The aircraft rules were amended to add the Aircraft Third Amendment rule of 2015, which amendment inserted Rule 37. The Rule 37 is pari materia with Article 9.5 of the protocol and essentially states that the DGCA has a duty to deregister an aircraft within 5 working days upon a proper application being filed by an IDERA holder. What is an IDERA? IDERA is an irrevocable deregistration and export request authorization that is issued by an operator in favor of a lessor or a security trustee or a financier, depending on how the transaction structure goes. But the IDERA holder has immense power in terms of ensuring a deregistration of the aircraft happens the moment there is a default. What Rule 37 did was put powers into the hands of the DGCA by giving them arming them with regulation and telling them that, okay, if there is a default now, we are making this amendment owing to the Cape Town Convention that if there is a default, you please deregister the aircraft within a period of time. However, this will be subject to any taxes that need to be paid to the government of India or any provider of public services in the Indian context. This was a very important step towards making India CTC compliant. The legislation was tested with multiple lessors filing for deregistration on SpiceJet, another Indian scheduled carrier, which defaulted under various leasing arrangements. This was very heavily contested by SpiceJet. It was a SpiceJet matter where, owing to the reluctance of the DGCA to deregister despite Rule 37, multiple creditors moved the High Court of Delhi for seeking relief. These cases were governed by CTC, and the point of question was the enforceability of IDERA provisions. The court, in this very, very important landmark judgment of Wilmington Trust, in which I have also been, a part, have been involved with, and have represented the lessors in this matter. It marked a turning point in the entire process of Cape Town and its interpretation and its application. Important observations were made by the court. Also, on honoring the international conventions. It is the first substantive decision under the Indian legal framework where the court analyzed Rule 37 and held that on proper application for deregistration being filed by the IDERA holder, the DGCA must deregister. And it clarified that after the Rule 37 is inserted in the aircraft rules, DGCA has been left with no discretion in the matter. So there is no debate about whether or not they need to seek the opinion of the operator on why the lease has been, terminated, or why is there a default, or is there a default at all by the operator, which was initially the practice of the DGCA, which still continues under other provisions where you seek deregistration under other provisions, for instance, Rule 36 of the aircraft rules. But under 37, if an application is filed, the DGCA must deregister. This important change brought about a lot of confidence and gave a lot of confidence to the industry and the relevance of the IDERA provision, and also seeing that Cape Town was moving gradually, but in a very strong way, into the legal framework that we have in India. In 2017, another important addition to aircraft rules was made by the addition of Rule 32A, which provided that once registration of an aircraft is cancelled under Rule 37, which is IDERA, which is again CTC, the IDERA provisions, the DGCA will have to take actions to facilitate export and physical transfer of the aircraft along with any spare engines that would be there. All of these remain subject to payment of fee to the relevant government departments. This filled the gap between deregistration and export, and very rightly so. However, the industry soon realized that there was still a gap between the export and accounting for all these credits that the operator might have owed to either the operator, the ground handling agency, the fuel supplier, the maintenance providers, the tax authorities. It is in this context that the standard operating procedure was issued by the DGCA in 2018. SOP has not only brought about, a streamlined process, but has also ensured that deregistration is now a very, very transparent process. The DGCA is tasked with the responsibility of publishing the IDERA application on its website. It's also now tasked with the responsibility of advising and listing out the designated officers across multiple airports once the deregistration request coordination is required after the IDERA application is filed. So you can get the list of all these officers on the DGCA website as to which airport has what dues vis-a-vis which operator, so that there is no ambiguity in your emailing them, getting the response, because we have seen this in the past in multiple repossessions that I've been a part of. To get a response from airport authority in time is impossible. A lot of crucial time is lost in communication. You wouldn't always get the communication right. You would never get the amount right. And even after you have paid, there is no certainty that you will get an NOC and a confirmation of payment and a confirmation of no dues from the operator. So this has certainly streamlined and brought about transparency. They're also supposed to now issue you a fair flight permit once after all these dues have been settled. And they're also supposed to help you with the flight out of the aircraft. So this SOP, what it did was this was one of the last things that we did in terms of making changes into the regulations that were affecting Cape Town Convention and Indian legal framework and the operators very much. It brought about transparency, and a lot of movement went into this. In April 2019, when Jet Airways entered the resolution process, we got to test this entire change that had been brought about in the framework owing to the Cape Town Convention. And it was a huge airline, more than 100 aircraft under their wings. And whilst it was very upsetting to see Jet Airways go down, which is one of the best products that Indian market has seen thus far, but the IDERA process and the rights under Cape Town Convention were fully honored by the DGCA, by the operator. And I would say, in my experience, we saw 80% of the aircraft deregistered without any hassle. There were some aircraft which got stuck, and there were a lot of litigation that went on with respect to those aircraft, particularly owing to the fact that those were finance leased aircraft. Some of the aircraft, I don't exactly remember the number, but quite a few of the aircraft were financed by the US Exim, and these were the aircraft on which there was an entrenched litigation, which took a bit of time, and that was the only derailment. I don't think that's the aspect for today's webinar, but yes, those were some aircraft which did not deregister under the Cape Town Convention. Other than that, I think we could test and see the process. Most of the aircraft were either deregistered or they were adopted and leased internally to another operator in India, which also entailed multiple changes in the legal framework to ensure that leasing within India after an import has happened does not trigger another set of, customs duty or GST or, any other kind of tax implication, which would just which just result in making the cost of leasing go extremely up. So we were able to do that, and none of it would have been possible without the collaboration of the government, the industry, the aviation working group, which has been spearheading this entire process since the very inception of AWG. They are the one who have been driving it. But it has been a journey to work alongside all these people. And it has been important to see this because everybody has contributed to it and everybody understands the industry, every part of the industry understands the relevance of Cape Town because it brings a lot of confidence into the market by ensuring that your credit into the aircraft, your asset, which is aircraft itself, and your right to go after your credit and your asset is completely secured, not just in one jurisdiction, but another. So you can keep toggling jurisdiction, but are you secured is the most important bit. And that is what Cape Town is out there to achieve. And with the promulgation of the current enactment, I think we have come a long way. And I say long way because this is a short form legislation. We have made a lot of progress here, but there is a lot of rulemaking that is yet to happen under this, which we'll touch upon later into the webinar. The current enactment is the third attempt at enforcing and enacting, legislating the Cape Town Convention. The first was the Cape Town Convention Bill of 2018, followed by the Protection and Enforcement of Interest in Aircraft Objects Bill of 2022. Despite the 2022 bill being a comprehensive piece of legislation, it was a very lengthy piece of legislation that we worked with alongside the industry and the government. It was also up for public comments for some time in 2022. The government, however, has opted for a more concise approach, very short, crisp legislation, like I just mentioned. By relying on the language of CTC and protocol, the current approach certainly aims to reduce ambiguity in the interpretation. We can go to the next slide, Shreya. The current legislation provides for a streamlined definition. Section 2 provides for clear definition in terms of international interest and creditors, ensuring clarity, compliance with the convention. It relies on all the definitions that is provided in the convention and the protocol. Section 5 details the operation of the international registry, detailing the role of DGCA, enhancing efficiency and transparency in aircraft registration and the procedures around it, which certainly enhances international registry. And by making DGCA the authority for ensuring registration, the registry authority, what it will also do is bring within its ambit all the transactions that's happening on the domestic level within India, the national transactions. Whilst up until now it has been seen as something that the small operators might want to do or not want to do, but I think it is the time when they will start seeing value in ensuring that their asset is fully secured. And by making DGCA the registry authority under this current act, I think this is something that can be there is a huge possibility of this being achieved, but maybe in a gradual way. But I'm hoping that this does happen. Section 2M designates the DGCA as the registry authority, centralizing aircraft registration responsibility. That is the point I just covered. Next slide, Shreya. Overriding effect of the Act. Section 9 is probably one of the most important sections of this Act. It provides for the overriding effect that the Act has on any other conflicting legislation. We will touch upon it again in the coming slides. Next slide, Shreya. Rulemaking and declarations. So I'll take the last slide and this slide together. What Section 9 does, which is bring to give a lot of credibility to the Cape Town rights. We have seen many conflict with multiple provisions that Indian law has enshrined in multiple statutes. But one of the most important ones, which was a direct conflict and a major challenge, was the Insolvency and Bankruptcy Code, with which we have been seeing a very direct conflict, which has been addressed by this provision of Section 9. The provision also, what it does is that it provides that in addition, this provision is in addition and not in derogation of any other law for the time being, of course. This is very important at the moment because the rules have not been framed under the Act as of now, and we are protected, the lessors and the aircraft. Let's call it the aircraft interest. So aircraft interest right now is protected by multiple reforms that have happened that we just discussed, from whether it's 37, 32A, SOP. This is the place where your rights are protected, and these rights are right now safeguarded and governed by these acts. So as long as this act does not overrule or override all the existing provisions and is in addition to all of them, is something very important, and they have clarified it in this piece of legislation. The provisions of this act, they have also carved out under Section 9, they're also very clearly carving out and protecting the rights and interest of the government and entity in terms of taxes and any dues that have to be paid to the public provider of private providers of public services have been completely secured. The difference that I see here is in the Rule 37, this entire carve out of ensuring that the dues vis-a-vis the government is always paid. is something that is coming out of India's declaration under the convention, which protects India's non-consensual rights and interest, which is one of the rights is to be paid, the government being paid whenever there is a due pending vis-a-vis anything, taxes, any fuel, maintenance, anything that comes within that provision of providing services, public services. So the Rule 37 had a carve out which provided that the only dues that have to be paid by the creditor, by the IDERA holder, while deregistering is the dues that have triggered from the time of declared default, which is when you serve the notice of default, to the time when you fly out the aircraft. That is the period you cover when you're paying the dues to the government. But that carve out is not present in this section. And this is something that we would hope to see when the legislation, the sub-regulations come into picture, the rulemaking that comes into picture. The next section, the slide on which we are right now, is one of the more important bits, Section 11, which preserves India's right. Apart from rulemaking, that is very important. It also preserves India's rights and very clearly carved out that India has a right to withdraw or make any changes to any declaration that it has made thus far under either the convention and the protocol. And it also preserves its right to make amendments to this Act, the 2025 Act, to ensure that it is in line with their declarations, which they have the right to change. Next slide, Shreya. Insolvency remedies have been very clearly carved out in the legislation. Section 6 provides creditors with remedies in case where debtor is in possession of the aircraft. Article 11 of the protocol applies mutatis mutandis. India, under its declaration, has opted for Article 11 and Alternative A, which gives you a remedy period, a waiting period of 60 working days, whereafter the debtor has to return your aircraft without any, there is literally, with the insertion of this section, there's literally, again, no ambiguity in the scope of this provision. So the aircraft is to be returned either after the waiting period or upon termination of the lease, whichever is earlier. So this provision is really one of the more important provisions. I think the entire act is made up of 5-6 sections, more important sections, and whereafter I think most of it will go into rulemaking, and this is certainly amongst the most important ones. Next section, yeah. Deregistration and export request authorization is something that we just discussed in detail. It is the IDERA provision. And under this 2025 Act, we are going back to the protocol itself, which enunciates the entire process of how a deregistration has to happen, which is completely in alliance of Rule 37. And I believe now the government is working on the rulemaking under the 2025 Act. We will see multiple, regulations which will be addressing this point. Right now, under Indian regulations, when such a situation arises, we will go back to Rule 37, given this Act makes provisions for such a situation till the time there is rulemaking. In terms of jurisdiction, I think this is very important that it came about with this section, because multiple times we have struggled with jurisdiction in the initial time when we saw repossessions happening in India. And Section 8 certainly provides a very clear-cut framework where you can simply go to the High Court. Any High Court with territorial jurisdiction had jurisdiction under CTC, simplifies the process quite a bit. So what we see with these many changes in the sector, which have all culminated into the legislation of 2025, we see multiple things coming into fore. For instance, the OECD discounts. India is now probably eligible for OECD discount, which can be up to 10% of your financing cost. Lower leasing costs for airlines, because I think airlines are now more empowered with the promulgation of CTC and adoption of a legal framework. The airlines are in a better space to negotiate better terms with the lessors, because the risk in the jurisdiction has reduced quite a bit. We have seen an enhanced CTC compliance index. So the moment India ratified the convention and the day it came into force, which is the first day of this month that it came into force, we saw a jump of 10 points into India's CTC compliance index scores, which means a lot in terms of giving credence to a particular jurisdiction. Lower leasing costs for airlines and impact on fares for flyers. I mean, this impact on fares for flyers is something that we would like to believe is something that will trickle down. Whether or not it does happen, how simple it is for it to happen, if there is a cost saving by the airline, does it certainly flow down to the customers and affordability of the customers and ultimate consumers? I'm not sure that it will happen, but is there a scope for it? Is there an anticipation that that will happen? Yes, and I think ministry has one of the reasons, and one of the reasons that was quoted by the minister himself was that they are looking at it because they feel very strongly that a very strong jurisdiction, a very secure jurisdiction, brings down the credit rate at which you raise credit, and therefore it should ultimately, the saving should somehow translate into benefits to the ultimate consumer. Hopefully that will happen. Support from the government, we have seen it thus far, and therefore we are here. But I would say support from the government is something that we will need to see even in future in terms of rulemaking. On top of it, India is a very, very, a difficult jurisdiction. We have seen multiple challenges in the past. We have seen in 10 years multiple airline failures. So I think support from the government is very important in bolstering the space and continued, access to CTC and collaboration with industry is something that government should not lose sight of, and the industry should not lose sight of collaboration with the government. One of the most important things that we just discussed in the previous slides was the stark difference and conflict between leaseholders' right versus the IBC implications. We are picking this subject amongst all of the important topics because this is one of the reasons why this entire 2025 legislation picked up speed, and it created a lot of backlash. This is all in the context of the Go Air insolvency. Whilst CTC gives you right under while CTC gives you rights under Rule 37 to secure your equipment, to deregister your equipment, to get control of it, IBC on the same time ensures that there is a moratorium and your assets cannot be disturbed in that moment. You have no right to disturb the assets once a moratorium is in progress under the Insolvency and Bankruptcy Code. So this entire conflict was addressed during the Go Air insolvency process. Now it is addressed in the 2025 legislation by virtue of proper promulgation and giving rights of, giving CTC a higher right than the IBC. But what triggered this? At this point, I think I'll hand it over to my colleague Shreya to give you a detailed, background of what Go Air case was all about and how we have landed up here. Shreya?
Yes. Thank you, Neha. I'll be speaking about Go Air insolvency and giving you all an overview of general events that perspired and the litigation which happened, along with the interplay between IBC and the CTC regime that Neha just explained. So, to give you a background, in 2023, Go Air filed for insolvency under Section 10 of the Insolvency and Bankruptcy Code, that is IBC. This Section 10 provides any corporate debtor an opportunity or an avenue to file for a voluntary corporate insolvency process against itself. Why was this Section 10 application filed? This was on account of defaults on payment which were being made by Go Air against several of its vendors and lessors. The Go Air was also basically defaulting on the lease rentals. All of this highlighted several operational issues being faced by the airline company, which is Go Air. One of the major reasons behind it was the engine supply issue which occurred. The lessors in their notices and several other platforms also, they mentioned that defective engines which were being provided by Pratt and Whitney were exacerbating the financial troubles being faced by the airline company. Go Air has also mentioned that due to these defective engines, several of its fleet or the aircrafts were grounded, which resulted into it defaulting on the payments of its vendors or lessors. So on account of all of this, the Section 10 application was filed, which was admitted by the NCLT, which is the National Company Law Tribunal, on May 10, 2023. and the corporate insolvency resolution process began against Go Air. With the uh, start of the resolution process, an RP, which is a resolution profession, was appointed to manage the affairs of Go Air and also with an aim to facilitate the recovery of the company. What is one of the most important point here is that with the initiation of resolution process, a imposition of moratorium period also happens. What is moratorium? As Neha just explained, under section 14 of the IBC, when a moratorium is imposed, all the recovery actions against the concerned company or the corporate debtor gets halted, and none of the assets of the company can be touched by anyone else. However, at this point of time, the lessors of Go Air argued that moratorium could not be imposed on the aircrafts because before filing of this application to the NCLT, the lessors had already terminated their lease agreement. So essentially, the aircrafts were not the assets in possession of Go Air. However, when they went to the DGCA, which is the Directorate General of Civil Aviation, for deregistration of the aircraft, DGCA cited the imposition of moratorium as a reason for not deregistering the aircraft. Owing to all of this and their aircrafts not being deregistered by the DGCA, the lessors of Go Air also filed a writ petition while this entire adjudication of moratorium period and its applicability on the Go Air case was pending before NCLT. This writ petition was filed by the lessors of Go Air in Delhi High Court. In the meantime, when this writ petition was also pending, there was a Ministry of Corporate Affairs notification dated 3rd October 2023, which came into effect. This notification precisely excluded all the aircraft and aircraft objects from the moratorium, from the purview of moratorium, essentially, from Section 14 of IBC, which addressed the conflicts with the CTC, which were prevailing in the previous regime. This was also flowing down from the larger idea of Cape Town Convention, the CTC bill, which aims to facilitate the financing and leasing of the aircraft. In light of this MCA notification and also reading it with the aircraft rule 37, which Neha explained, Delhi High Court took into account the challenges which were being faced by the lessors and gave its ruling on the following points. The most important aspect of the Delhi High Court's ruling in the writ petition was that this MCA notification is applicable in the present Go Air case. Why was this important? Because Go Air had argued before the court that this MCA notification, which exempted the aircraft and aircraft objects from the purview of moratorium, would not be applicable in this case, as the writ petition was filed before this MCA notification came into effect. However, Delhi High Court, taking a larger stance, stated that this MCA notification would be applicable because this is only clarificatory in nature. That is to say, it is not putting anything new on the table, and it is merely clarifying the conditions which have already prevailed. That is, India was already a signatory to the CTC, and everything, including the insolvency procedure, which is prescribed under the CTC, must be adhered to by India as well. The Delhi High Court also stated that India's accession to the CTC also mandates adherence to the insolvency steps and held that there is no inconsistency between Section 4, that is the Section 14, that is the moratorium provision, and the CTC. The court basically took a harmonious construction or a harmonious interpretation of Section 14 and stated that it is in compliance with the larger ambit of CTC and the aircraft rules. And on account of all of this, the High Court directed the DGCA to deregister all the aircrafts which were leased out to Go Air so that the lessors would be in a position to deregister to get the aircraft in that position and fly it out. Although there were some instances of the lessors not being able to actually physically take the aircraft out of the country, however, it was ensured by the DGCA that all the 54 aircrafts which were leased out to Go Air were deregistered. So I think this entire ruling of the Delhi High Court was in line with the larger compliance or in line with the thought that international treaty obligations warrant stricter interpretation, and adherence to them or any deviation from them would have a larger impact on the business community or on the larger impact on the business interest of the country, which in turn a larger community, international community platform would not be recommendable. So any international treaty, especially the CTC and its provisions, must be adhered to by a country like India. So that's all on the case from my side. I would now request Neha to again take over the discussion.
Thank you, Shreya. Very nicely explained. Indeed, like Shreya mentioned, GoAir was considered a stable player in the Indian low-cost airline segment. With a growing fleet and a strong domestic presence, it had also extended its network. It was rebranding, was planning on going on public, had a strong order book. Despite all this, when they were hit by the engine crisis, the supply chain issue, which Pratt and Whitney was simultaneously hit with, it grounded nearly half of its fleet, and it was impossible for them to have, recovered from such crippled operations and failures at multiple ends. The insolvency marked a pivotal moment for Cape Town and India's legal framework, as it triggered a wave of uncertainties with the lessors. For they were seeing again that their aircraft were getting stuck one after the other, insolvency events happening in India in quick successions of the other. So it did become a kind of a challenge. Indian tribunals initially, just like Shreya explained, restrained such recoveries under the moratorium imposed under Section 14 of the IBC, revealing the lack of direct domestic implementation of the convention. And that is the reason why, and that is what brought about a lot of backlash, which backlash prompted the Ministry of Corporate Affairs to come out with the notification of October 23, reaffirming convention's precedence and superiority over IBC, which has now been confirmed in the 2025 Act itself. Despite this, significant delays, just like Shreya mentioned, did happen, and we have seen procedural hurdles, we have seen judicial reluctance to allow deregistration and repossession, underscoring the need for, more clearer, more codified domestic rules, thereby giving another reason to both the industry, the lessor, the community, the government to address the issue very quickly and with a proper legislative affirmation. And this, in my very limited opinion, was one of the reasons why all of this happened in very quick succession. And we now have a proper act in place which has integrated Cape Town into our legal framework. We can skip the slide, Shreya. I think we have touched upon these. Let's go to the MRO sector. I think we're running out of time. I'm really sorry, Udaya. I'll skip these two slides just so that we are in time to cover the MRO sector. The Indian MRO sector is huge, and I think it's positioned to get even more huge. We are seeing supply chain issues in the sector right now, and we are seeing major OEMs struggling with deliveries, because of which there is scarcity of aircraft in the sector, because of which we need more aircraft to be properly maintained. The old aircraft are still running. The ROI on the leasing has increased quite a bit, and it is quite the lessor's phase where you need your aircraft to be up in the air, and you need a very quick TAT on all these aircraft and equipments, engines, and it's a very good time for the MRO sector as well. And like I said in the beginning of the webinar, that the government of India had started deregulating and reducing the taxes on multiple aspects that affected the MRO industry quite a bit. And it's important to see the entire Indian industry, the aviation industry, which is a huge one, and it's growing at a pace like none other. Obviously, because we are a developing economy, obviously because we have a huge, a middle class population, which is now ready to spend on this kind of travel. Speaking of which, a particular assessment says that Indian travelers are expected to spend approximately $410 billion by 2030 on simply travel, not travel and tourism, but just travel. Some of the major services provided by an MRO are component support, line maintenance, and the maintenance of engines and aircraft. Of these, the engine and the APU maintenance accounts for more than 50% of the services provided by an MRO. Given the market dynamics, services provided by the Indian MRO sector, which were long restricted to line maintenance, is now moving forward into heavy maintenance and have found necessary support. The sector has found necessary support in the positive changes in the regulatory framework. For instance, changes in the customs duty, GST provisions, positive impact on the Indian MRO industry, which provides necessary fillip for it to not only cater to day-to-day needs of the industry in India, but also probably to be able to cater to the region at large at a good price, at a competitive rate. The maintenance of aircraft, the entire sector of maintenance, repair, and overhaul now benefits from 100% FDI under the automatic route. This combined with a uniform 5% IGST on imports of aircraft parts, components, testing equipments, tools, toolkits, regardless of classification, and several key regulatory changes, has the potential to transform our MRO industry as a major service provider in the sector. Some of the more important changes include extending the period for exporting goods imported for repairs from 6 months to 1 year, which can again be extended in certain circumstances, increasing the time limit for re-importing goods for repair under warranty from 3 years to 5 years, eliminating royalties and enhancing transparency and certainty in land allotment for MROs at airports run by the Airport Authority of India, reducing GST on MRO services from 18% to 5% with full input tax credit, treating transactions subcontracted by foreign original equipment manufacturers or MROs to domestic MROs as exports with zero rated GST, exempting customs duty on tools and toolkits. These were some major changes. All have happened over the period of years, not together, but they have all added to the efficiency of the MRO sector. They pave a way for a better, more competitive MRO sector, a home-based sector, which will now have the ability to compete with the global market, which will now have the probably the efficiency to increase its capacity and then render the services, to the market at large. The sector is growing at a fast pace. The legal framework, along with meaningful and directional policy initiatives, are important elements to ensure continued growth and protection of interest of relevant stakeholders in the MRO sector. I would say MRO sector has seen some very good reforms in the past. It's about how the sector takes it, to what extent can they benefit from it, and what is the challenges that they are facing in the sector, because I think the government remains very open to understand the challenges and to keep working on it to ensure a seamless process that can become a strong business facility, business proposition for the industry, for the MRO industry. Next slide, Shreya. I think we have broadly covered all aspects, and protection of interest in the aircraft object is certainly a major step towards making India a very strong jurisdiction, ensuring that the credit that is made to us is at a low cost, ensuring that the lessors have the confidence to lease into our jurisdiction and still rest assured that their aircraft will remain secure. Having said that, we also have to see the rule making. We have to see how judiciary is informed and educated about this entire convention, this entire, the Act of 2025. Because without that education, that has to go to DGCA, the judiciary, the people who are working in the sector. It's very difficult to ensure the right kind of compliance, the right kind of efficiency, and the right kind of result. So the work is not over. It has begun, but it's a very big step. And it does align with the global standards. It brings us at par with the more developed economies where you already see these regulations in place, and therefore some kind of a process, some kind of transparency in how things work and efficiency thereof. Implications, I think we have discussed the implications across the entire thing. And what my takeaway from this entire thing is that we have come a long way in the past decade and a half in ensuring compliance with Cape Town Convention in bits and pieces. With this legislation, we consolidate it. And how we take this legislation forward in terms of rulemaking and educating every single stakeholder, from judiciary to government to DGCA to regulators to industry participants, is very important to ensure efficiency in enactment and enforcement of this regulation. With that, I think I'll call this, I'll bring an end to this webinar. And I'm absolutely sorry. I'm very sorry, Udaya. I've taken way more time than, was, supposed to. I'm really sorry.
Thank you, Neha. I think that was very insightful. Thank you, Shreya, as well. I can see a couple of questions on the chat, Neha. It's from David. He's with the econ section at the US Embassy. So, David, would you want to unmute and take that question, or should I just read that? Let me know how you want to proceed.
Sure. Yeah, I'm happy to read it. So the first question I had is, well, firstly, thank you for the comprehensive presentation. It was really enlightening. The first question I had is the aviation. Which organization oversees the aviation working group? Is this a USIBC or is this a government working group?
So no, Aviation Working Group is a not-for-profit organization. It was founded by Boeing and Airbus sometimes in 1994, 95, essentially to address the issue of default and uniform regulations across jurisdictions. And that is when it was formed. It is based out of US. And and they have been working, and they are the ones which have worked with UNIDWA to ensure the legislative the framework of Cape Town comes into action. And after their work, continued work, so AWG works with multiple law firms in the US, major law firms, to bring about to collaboration in terms of expertise. And they also collaborated with UNIDWA to bring about the convention and the protocol. And there are multiple protocols apart from the aircraft protocol. We have rail protocol, we have space protocol. And AWG also is tasked with a major work to collaborate across with jurisdictions, with bureaucrats, with industry, with organization. It is one of the most leading bodies in the field of aviation, which drives changes with respect to Cape Town Convention across all jurisdictions.
Thank you. The second question I had is I forgot who mentioned it, but somebody said that it's estimated that by 2030, Indians will spend $410 billion on travel alone. Is that an annual figure or is that a specific period?
No, I think it's a figure which there is a study which estimates that by the time we hit 2030, Indian travelers would have spent $410 billion on travel, of which a major part is now aviation, aircraft travel. So it's not a yearly figure, but it contemplates the expenditure, the amount of money that would be spent from now to 2030, which is 15 years.
It's 13 years. So it's 2030 or 2040?
2030.
2030. Okay.
Oh, yeah, 5 years. Yes, 5 years. Sorry, my wrong.
Oh, it's okay.
Yeah.
Thank you, Neha. Thank you, David. Do we have any other questions from the participants today? If you could just unmute yourself or raise your hand, we could call you up. If not, then Neha, I have a question for you. Now that, yes, Samir. Go ahead, Samir.
Please carry on.
No, Neha, I was just wondering, now that the act is in place, what do you think are the most critical steps for the stakeholders? How do they begin?
I think the stakeholders at the moment are at a good space because the act has come into force. You see, like we were just discussing before, the webinar. The act has come into force, which is giving a lot of credence to the Cape Town Convention and its hold on the Indian legal framework. What we are looking at right now is that government is working on the rule making. I think it's very important that the rules are unambiguous and very clearly set out so that it also manages a very efficient process, a step-by-step process about everything, who to go to, what is the time, what is your expectation vis-a-vis a certain procedure, so that there is a limited scope of ambiguity and limited scope of interpretation And I think they have tried to tackle it by making a short form legislation and relying entirely on the convention and the protocols text itself. But still, when you're making rule, there is room for further improvisation, trying to find what are the things that can lead to. For instance, SOP is something in terms of when deregistration has to trigger. You have to find a rule, a process that has to be in place, which you can follow to get your results, and that too in a very time bound manner. Otherwise, in an aircraft transaction or in an aircraft repossession scenario, every day on ground is a lot of money. It can also lead to maintenance costs. It can lead to cannibalization. It can lead to releasing. You don't know, they can be multiple things which fall as a domino if things don't happen in time. And therefore, time is of huge essence in transactions like this. And while rulemaking, I'm absolutely certain that it will be one of the more important agendas for the industry and the government to ensure that there is least amount of ambiguity and efficiency in process when addressing these issues.
Yes, thanks for that, Neha. Thanks. Samir, you were saying something?
Yeah, Neha, just I'm curious, since you're mentioning about time-bound procedural issues to be sorted, just want to understand if there is any defined timeline by which things are sort of in place for the industry to uh, take a deep breath without any further complications going forward. Is the government engaging with industry, doing multiple stakeholder consultations? What is the process looking like at this point?
I think the government has already initiated, as far as I understand, they already had a very high level uh, interaction with the stakeholders to now align the process of rulemaking, to take a broader view of who the stakeholders are, what is it that we intend to address. And I think they have already held one, very informal, high-level meeting already. And I think it will be very important. And we have seen government participate and actually lead and collaborate with the international organization, particularly AWG, to see that these actions come to right kind of fruition by, active participation by the members, in which they certainly identify. But government has already initiated the process to answer your question. And how quickly, that is very difficult for me to answer right now. And time-bound fashion, yes, but when rulemaking is a very tricky process, you want to cover all grounds. I wouldn't say there is a very huge timeline, correct timeline that I can put to it. But I think the government is right now working at a speed. They intend to address it. They are very serious about addressing it, and they are taking meaningful steps to do it. So let's hope soon.
Cool, thanks. I think just to provide a context, when the current civil aviation minister took over the ministry, we did a call on and we sort of highlighted some of the issues that member companies are facing in this regard. And he was very positive in his sort of approach. And I think he is someone who is very pro-industry and friendly. I think things should sort of fall in place very quickly. So just on that note, just wanted to highlight that. So if there is any industry representation that is required from our end, we are happy to work with Neha going forward. So just wanted to also set that out to everyone. So as a part of our engagement in aerospace and defense, we are sort of creating a subcommittee for civil aviation as well, and to carry forward discussions that like this going forward as well. Uday, over to you.
Thank you. Thank you, Samir. DJ, you have a question as well. Please go ahead.
Yes, sir. Neha, just a very quick question. You did mention that the aviation sector is set for a dynamic growth and airlines all gearing up. But you did talk about briefly the MRO sector, but are the MRO facilities in India ready to match the growth of the aviation fleet that's going to come in? A. And B, probably this question had been raising it to the and others. The dual use of MROs. We have defense MROs which are there not being utilized up to the capacity. That's something we've done, or is any efforts being undertaken to actually get them utilized properly? Dual use can be the best way, and that's the best practice across globally. Why not in India? Thank you.
Very, very interesting questions, I would say. To answer your first question, you know, Indian MRO certainly don't have the capacity right now. You very rightly pointed it out, and there is a reason why, which I was trying to, uh, uh, elaborate or allude to during the webinar. That's precisely because I think it's a very vicious circle. When the taxation and the rates on your service provision is so high, you are never competitive enough to either increase capacity or scale up, because you would always lose in the bigger market because you are so expensive and yet you don't have the capacity. So I think with the changes that came about or have been coming about in the past, 4 or 5 years, we are seeing changes in the MRO industry. Not that it's going to have a turnaround overnight, but they are building capacity. And by the time the aircraft start coming in, and we are looking at aircraft entry into India for the 10, 15 years from now to 10, 15 years, that these aircraft will come into India, and most will be in midlife, requiring major maintenance would be after six years of their entry into India. And if I just look at the aircraft and aircraft alone, I think by that time Indian MRO industry would be at a good position to start catering to these, and also to other operators, and which are not a part of the Indian jurisdiction, but of the more open space, of let's say APAC, EMEA, wherever. Point is that, do they have capacity? No. Will they be able to build it? I'm quite positive they will be, with all these changes. And they will also have a lot of support from the Indian government in terms of what they already have and what they can get in the future, and what is the roadblocks that they are facing. Vis-a-vis dual use of MRO, yes, we have been hearing a lot of chatter from the industry, but I think the security, I would say the entire bit around security and ensuring there is they are able to control that bit completely, is a reason why the government has always been reluctant in, making it a dual process. Whilst you very correctly mentioned they are not working at their full capacity, there is certainly scope. But are we at a space where we can manage this absolute security aspect completely? I think that is where it comes, and we don't have an answer to. But it's not as if this has not been raised to the government. It has been raised. I wouldn't have all the answers to this aspect. I would very happily submit to probably Udaya and Sameer as to what are their thoughts on this. But this is one aspect where I, in my opinion, in my limited view, I think it's always the security angle that tops everything else, and that's where the government probably is not very comfortable making it the defense MROs open for private participation and services being provided to general aviation as well.
Thank you.
If I may just jump in at this point to answer your question, DJ. So the current Civil Aviation Secretary was someone who was DG Acquisition in the Ministry of Defense. And when we had called on him, his emphasis was to discuss on MRO. So there probably, this is something that I'm just thinking aloud, there is a possibility of him pushing the case for dual use MRO going forward. So let's hope for the best, and maybe we'll do a call on with him and share more details once we have a chat with him.
Thanks, Sameer.
Thank you. I think Neha, Shreya, we have covered a lot of ground today. So we'll not keep you longer here. I know you have other commitments as well towards the end of the day. So do others with their families. And for our US colleagues, I'm so grateful to you. I mean, have a great day ahead. Thank you so much for joining us for this whole webinar thing today. And we will be happy to share across the presentation that TriLegal has prepared, and we'll be sending a link across to you to download that. Have some questions, come back to us, come to USIBC, come back to TriLegal. We'll be happy to address those, and we look forward to setting up more webinars in future. Thank you so much, all of you.
Thank you.
Yeah.
Thanks, Udaya.
Thank
Thank you, Deya. Thank you. Thank you,
Thank
Neha
you.
and Shreya. Thanks.
Thank you.
you.
Bye. Bye.
Thank you. Bye-bye.
Thank you, Deya.
Bye-bye.
Bye-bye. Bye. Bye.